a production of the Mesa Chamber of Commerce. Visit us at mesachamber.org.
Well, thank you everyone for being here today. My name is Andrea Alacote. I am the Diversity and Special Projects Manager at the City of Mesa, and I am here today to give an overview on the Non-Discrimination Ordinance as it pertains to businesses. So really the purpose of our Non-Discrimination Ordinance for the city is to provide equal access to goods, services, employment, and housing within the city. We want to make sure that everyone has a fair opportunity to be able to go to a particular business and get services, obtain housing, or even come through our city doors and get the services that they need. So within the Non-Discrimination Ordinance, there are 14 protected classes, and each one of these is identified within our ordinance itself. But as you can see, many of them are pretty similar to what you have seen in other state or federal protections, like your EEOC, Equal Opportunity Act, Fair Housing, ADA, which is your Americans with Disabilities Act. So just a quick run through: race, sex, color, sexual orientation, ethnicity, gender, national origin, gender identity, age, veteran status, disability, marital status, religion, and familial status. So again, the NDO applies to any of the following areas. These are the main categories that the discrimination ordinance is going to apply within businesses or places of public accommodation. So that's anywhere that you are open to the public and serving folks. Employers that have 5 employees or more. If you are 4 or less, you would be exempt from the ordinance within the employment factor. However, if you are serving the public, you would still have to be cognizant of the public accommodation feature. Owners or lessors of sale or rental of housing dwelling units. So if you are an individual who has property and are renting out property to people other than your family members, this ordinance can still apply. Or if you are a larger complex like apartments, duplexes, if you have even a in-law unit that is not within your property lot, if you have multiple lots and you have different units on that area that you're managing, those would all be examples that could possibly apply under our ordinance. Labor organizations, and that is within its membership, application, or employees of that organization. And then, of course, us as the city, we are holding ourselves to the same standard by ensuring that our facilities are within our employment and within our contracts and vendors. We are holding to the ordinance. So there are some exclusions. And I'm just going to briefly cover some of these. We do spell out in more detail as to how these exclusions can apply. A lot of times there's things like your tax status or different types of classification of your business that if we were to receive a complaint that we would need to investigate to see if these exclusions are applicable. So just as a high level overview, federal government or state agencies are exempt, as are religious, public, and charter schools, and religious corporations or organizations. So many of those aren't necessarily going to apply to businesses, but those are good to be aware of. Where we want to pay attention is within public accommodation, so that's servicing the public. If you have any beneficial pricing, so things like senior discounts or student pricing, those are still absolutely okay to do because they provide a benefit to segments of our population that would otherwise be in need. And then speech and expressive activities. So this is a very, very intricate category that unfortunately I am not an attorney or a lawyer, so I wouldn't be able to give a lot of really great examples, but it's mindful to be aware that free speech is protected within this ordinance. So things that you were saying as an individual can at times be protected under free and expressive speech. However, it is, again, something that we would recommend to either go through the ordinance, or if there's a particular circumstance that you would like to discuss with the city, we can certainly get you in contact with an attorney who would let you know what this robust category can cover. So who can make a complaint? Anyone that feels that they have been discriminated against any of those 14 classes, and it's within a public accommodation, housing, those list of areas that we had mentioned, they can essentially fill out the complaint form. It is a complaint-driven process. So what's really important to note is that the city is not going to be proactively going out there and inspecting or looking for acts of violation against the non-discrimination ordinance. The person would need to file the complaint, and it would have to be within 90 days of the alleged act. And there is no cost or fee to file that complaint. But what's really important is that it cannot be anonymous. So the person would have to be willing to disclose their information, and that would then go to the business that the complaint is being filed against. So what happens when a complaint is made? The city, which would be myself as the diversity manager and behalf of the city manager's office, as well as the city attorney's office, would review the complaint just to make sure that it aligns with all of the criteria that we have listed within the ordinance. We would contact the complainant just to verify whether the complaint was accepted or denied, and once again, go through and make sure that they understand your information is going to be released. That you have to be willing to provide us the information that we may request to support your claim of discrimination. They have to participate in a mediation process, which we'll get into in just a minute. And they would have to be willing, they would be referred to one of the state or federal processes if it aligns with that. So our non-discrimination ordinance is really intended to fill in the gaps of what state or federal regulations don't cover. So there are things like within employment laws, the threshold is typically going to be 15 or up. So with ours being 5 and up, there is between 5 and 10 employees. 5 and 15, that's a range of 10 employees that would be covered within our ordinance for investigation. But should a business have 16 or more, they are going to be, or 15 or more, give an example of 16, they would be referred to the EEOC for that complaint investigation. So again, there is a lot of relations with the state and federal regulations, and that is going to be on the city for us to be able to manage, which is the appropriate process to go through. So if the city deems that we are going to accept the complaint for further along in the process, we will contact the individual or business that the discrimination complaint is briefed against. We will notify them both through a phone call, but also in writing, that they are going to be receiving a copy of the complaint and would be provided any of the supporting materials that would go along with the complaint. And then the individual or business would have 30 days to file their response to the complaint. So the city is going to be looking at both sides of the complaint, just as it would with any civil violation process. We're going to be looking at both sides of the story. And so we want to give any business owner or organization an opportunity to provide information that may rebut or support the claim that's being made. If no response is filed within that 30-day window, then the city is going to deem that as admitting to the complaint, essentially, and then we would follow along with the civil violation process. Otherwise, if you do file within that 30-day window, then we're going to proceed into the next step of the process. And that is going to be the mediation or alternative means of resolution. So this process is set up very similarly to what could be compared to our code violation. If you have a neighbor that has very high weeds, a code compliance officer is going to go out and give a written warning. Or they may speak to the owner and have a conversation with them and let them know this is not an act that's acceptable within our city ordinances. The mediation and alternative means of resolution process is set up very similarly. we want to be able to educate business owners. We want to provide them an opportunity to essentially right their wrong if one was made. And so we want to be able to bring both parties into the room and have a very productive conversation in order to resolve the complaint before it gets to a violation process. So this is actually required as the first step before any citation is issued within a first-time complaint. And then should there be a second or third complaint, we'll assess if necessary. But both parties are expected to be participating in that conversation in good faith. Should either party, whether it's the complainant, if they choose not to participate in good faith, then we are going to cancel out the investigation. If the complainant is not willing to meet us with part of that conversation, then it's very difficult for the city to be able to show any proof of burden. But if it is the individual or organization that is being grieved, that it is not participating in that conversation, again, that would give us means to be able to move forward into the violation process. And so what does that process look like? Once we have gone through that mediation or alternative means of resolution, and we find that we need to move forward with an investigation, and it does look, in fact, that there wasn't a discriminatory act that occurred, then we would go into a written citation, which is through our civil violation process. So again, comparative to a code compliance violation or traffic ticket, those are all examples through our civil courts. You would have the option to pay that particular fine or fee of the citation, or you would have the option to go through a civil hearing officer. And again, you would also then have at that time another opportunity in front of a civil hearing officer to either accept blame or deny the particular act of discrimination, and you would move along through our typical civil court hearing process. The penalties for a first-time violation, and this is standard across all of our civil violations, is going to be $300. A second violation is between $300 to $2,500, and then a third violation is $600 to $2,500 or more. And after a third violation, that can then be transferred into criminal. So what are some common questions related to business owners? How is the City of Mesa going to protect me and my business from any false complaints that come in? I think we kind of went through a lot of the very detailed process, and you can see that the city has an onus as well to be able to show a burden of proof that the discriminatory act had occurred. And you will also see that the mediation and resolution process is where we hope all, if not most, of the actual complaints are going to be addressed and handled. So we give both parties equal opportunity to take part in the conversation, and that is how we're going to hope to be able to prevent businesses from any false accusations. A discriminatory complaint has been filed against me or my business. What should I do? Again, you're going to be contacted by the city via phone call, email, and most importantly, the formal written notification in which it's going to outline exactly how you are to respond. And the most important thing to remember is that you have 30 days to respond. So as long as you're communicating with the city, then we are going to take that you are participating in good faith, and we will continue to work with you. Do I need to hire an attorney or if someone files a complaint? No, you don't. Civil violation process does not require any type of attorneys to be present. So again, as long as you are working with the city in due diligence, there should not be a need, but as always, you are allowed to include one in the process if you wish. Is my business required to construct unisex restrooms or retrofit any current restrooms? No, you do not need to install any new bathrooms or do any different signage. The ordinance does allow for single-sex facilities to exist. So essentially everything is operating as it is prior to the ordinance, in which you can have a male or female dressing room, you can have a male or female restroom, and that would still be okay. The big part is that you have to allow people to use the restroom to which they identify with. If a person comes in and they claim, identify or state that they're female, you don't have to ask the questions, but if they are choosing to use a female restroom, you will allow that person just as it was prior to the ordinance. I have sincerely held religious beliefs that conflict with the requirements of the ordinance. Am I still required to comply? This is where, again, First Amendment and freedom of speech come into play. And really the big answer and response here is it's going to be circumstantial. So if it is during the hiring process and you are not part of any of those exclusions, operations of business, for example, you are not a religious organization under tax code, then there's going to be circumstances where you do need to comply with the ordinance. However, if you are acting as an individual and you are making a personal statement outside of your public accommodation or hiring process, then there are going to be opportunities where freedom of speech and personal opinion can exist. So this is just one to be very familiar. Should you have any concerns with this area, you would want to look at our ordinance to see the different exclusions, or feel free to contact the city and we can certainly discuss any of those specific examples for you. What if a person tries to use the law to disguise inappropriate or unlawful activity? The ordinance is not a get out of jail free card. It is not going to protect anyone who is using it to commit a civil act or a criminal act. The most common example or question that we had received is since you are allowing folks to use the facilities to which they identify, perhaps a male is able to go into a female restroom and commit essentially a crime. They would not be able to use this ordinance as a cover for any inappropriate activities such as looting or violating others within that facility. Business owners would be able to contact the Mesa Police Department in violations of those other crimes, and they would not be deemed in violation of the non-discrimination ordinance for doing that. Again, this is another area where it is circumstantial based. So if you have any specific questions, we'd be happy to talk to you more specifically at the city regarding those circumstances. So promoting inclusion, going back to the purpose of this ordinance. Once again, what is gender identity and expression? That is, once again, truly recognizing that folks have the ability to express and appear and have mannerisms within the gender that they choose to identify, which may differ from the one that they were assigned at birth. And this ordinance and the City of Mesa and the Mesa community through this ordinance is going to choose to recognize and acknowledge those individuals for that designation. Does the ordinance mean that my women's only volleyball league or women's only gym is illegal? You can insert other examples into those specific categories as well. No, it does not mean that those are illegal. You can certainly still have female sports or male sports. Typically, you're going to see more female-oriented gyms. But those single-sex designated areas, again, restrooms, fitting rooms, nursing rooms, those organizations, affiliations, those groups or areas are able to exist at a single-sex designation. It's just simply that you need to allow a person who identifies as a female then to participate on that volleyball league or to be able to participate in that women's only gym. What are some things that I can do to make sure that my business is inclusive? We definitely recommend that you review any of your advertising, hiring practices, look at your marketing for your particular business, and just make sure that you are not excluding any of those 14 categories that we have listed below. You do not want to have listed anywhere within your hiring manual that, for example, a job requires a lot of physical skill, therefore a woman cannot fill this position. Those are examples that would not work within our non-discrimination or work against our non-discrimination ordinance, but also, quite frankly, a lot of other state and federal regulations out there. Train your supervisors and any staff that interacts with the public. Make sure that they're aware that, again, personal opinions related to the ordinance itself, it may not be able to be expressed while they're on the job if it is in opposing what the ordinance states and represents. Because this does cover public accommodation and areas within the community, we're asking all community members to make those within our community feel included and have equal access to treatment. Familiarize yourself with existing state and federal laws. Again, we touched on that. ADA, fair housing. The non-discrimination ordinance builds upon a lot of those, and so the types of examples or experiences that are listed in violation of these regulations are going to be very comparable to what we see within our non-discrimination ordinance. Don't make assumptions on a person's physical appearance. Engage with them and interact with them. So really what we're trying to achieve here is that we have a friendly, welcoming, livable, vibrant community. And so we just want to encourage our community to engage with each other and work with each other and make everyone feel welcome into your establishment. And then review the city's webpage or ask any questions. Our city webpage has a lot of the questions that you saw on this training do live on our website. So if you don't recall where to go to find this particular training, you can go to our website, www.mesaac.gov/civil rights. It's going to take you to a page that covers varying rights, our Title VI, our ADA information, but you'll see that there's a blue button at the top. And that'll take you straight then to our non-discrimination ordinance page. And again, everything that is listed in this PowerPoint presentation is included on that website. And then, if that's just too much to remember, at the bottom of every single webpage, we have a permanent fixated banner. There is a civil rights protection link. So all you need to do is go to our mesaac.gov webpage and scroll all the way to the bottom to this link, and that'll get you to all of this information easily. And that concludes the presentation. Thank you for your time and attention. Does anyone have any questions?
So, Andrea, if a particular complaint is referred to either a state or a federal agency, does that then move it out of the city's jurisdiction and basically it kind of moves along to that other agency that would handle that?
Correct. Thank you. Yes, it would. The city would have no part or interaction with that complaint unless, for whatever reason, that complaint was on the city and we were one of the parties involved, which we will never choose to be. But yes, thank you.
Stay connected to Mesa Chamber social media, email newsletters, Monday morning message, and mesachamber.org to always know what's happening at your Mesa Chamber.